Good afternoon, everyone. My name is Sibel Raver, and as Deputy Provost of New York University, it is my great pleasure to welcome you all here to the 2021 Jacob K. Javits Visiting Professorship Lecture. We're so glad that you've joined us for this momentous occasion. I'd like to thank Dean Morrison, his office, and Institutional Events Director Penelope Fernandez for hosting and organizing this year's Jacob K. Javits Lecture. This event is co-hosted each year by NYU and the Marion B. and Jacob K. Javits Foundation. We're also very fortunate to have Ms. Carla Javits with us today to share her commentary and closing thoughts. Carla is not only the chair of the Javits Family Foundation, but also the president and CEO of Rediff, a venture philanthropy bridging the public and private sectors. We're so grateful for this partnership, and we thank the foundation for their continued support. Today, we are honored to hear from two truly visionary colleagues here at NYU, Professor of Clinical Law, Deborah Archer, and Frederick I. and Grace Stokes Professor Melissa Murray. These two brilliant leaders are this year's awardees of the Jacob K. Javits Professorship. I extend my heartfelt congratulations to you both, Professor Archer and Professor Murray. Dean Trevor Morrison will introduce each professor and will kick off their discussion shortly. I also want to offer a brief word of congratulation to our inaugural Jacob Javits Graduate Fellowships for Leadership and Public Service to NYU Law students Cameron Johnson and Anna Applebaum. I'd also like to recognize the members of the Javits family who are in attendance today and to tell you a little bit about this prestigious award and its significance. The Jacob K. Javits Visiting Professorship was established in 2008 to honor the memory and the accomplishments of the four-term senator and to promote the values for which he fought. The professorship is awarded to an academic, lawyer, policymaker, journalist, historian, philosopher, or former elected official whose work focuses on an issue close to the senator's interests, including health, civil rights, labor, foreign policy, disability rights, education, employment fairness, and economic security for working Americans. Senator Javits had a long and distinguished career of dedicating his life's work to his community. Born and raised in New York, the senator earned a law degree from NYU, serving our nation as New York's 21st Congressional District in the US House of Representatives, then as New York State's Attorney General, and then as a member of the US Senate. During his time in office, Senator Javits sponsored an exceptional array of landmark legislation. His accomplishments are far too many to name, but let me just highlight a few. He helped to create the National Endowment for the Arts and the Humanities. In 1973, he sponsored the War Powers Act, which limits the president's power to declare war without congressional approval. And he helped to pass the Employee Retirement Income Security Act, which ensures a fair private pension system. In recognition of his commitment to public service, in 1983, Senator Javits was awarded both the Charles Evan Hughes Gold Medal for his courageous leadership in governmental, civic, and humanitarian affairs, and the Presidential Medal of Freedom for his exceptionally meritorious contributions to the country. The senator believes strongly in building effective coalitions to pass legislation that benefits the American people. It is in his honor that we are gathered here today. Without further ado, I'll turn the floor over to Trevor Morrison, my colleague and Dean of the New York University School of Law.
Thank you, Sibel, and thanks to all of you for joining us. And let me add my personal thanks to the Javits family as well for making this professorship and this lecture possible. It's my great pleasure to introduce my two colleagues, Deborah Archer and Melissa Murray, for what I'm sure will be a really interesting conversation this afternoon. So let me introduce each of them and then give you a bit of an idea of the run of show as we plan to proceed this afternoon. Deborah Archer is professor of clinical law at NYU School of Law, where she is also a faculty co-director of our Center on Race, Inequality, and the Law. As a teacher, she leads our very successful civil rights clinic, and through her scholarship and teaching, she's a nationally recognized expert in civil rights, civil liberties, and racial justice. She is also the president of the American Civil Liberties Union, where she continues to provide a critical leading role nationally on issues of civil liberties and civil rights. She previously worked as an attorney with the American Civil Liberties Union and the NAACP Legal Defense and Education Fund, where she litigated in the areas of voting rights, employment discrimination, and school desegregation. Before joining our faculty, she was a member of the faculty at New York Law School for 15 years, and was in private practice before that as well. She is a graduate of Yale Law School and Smith College. Melissa Murray is the Frederick I. and Grace Stokes Professor of Law here at NYU Law, where she is also the faculty director of the Birnbaum Women's Leadership Network. She teaches constitutional law, family law, criminal law, and reproductive rights and justice, among other courses. And her research focuses on the legal regulation of sex and sexuality and encompasses such topics as marriage and its alternatives, the marriage equality debate, the legal recognition of caregiving, and reproductive rights and justice. In addition to being a prolific scholar whose work has appeared in virtually all leading law reviews, she's written many pieces for broader audiences that have been published in major newspapers and magazines, and she appears frequently on television as a legal commentator. A graduate of Yale Law School and the University of Virginia, she clerked for then Judge Sonia Sotomayor when she was sitting on the US Court of Appeals for the Second Circuit, and for Judge Stephan Underhill of the US District Court for the District of Connecticut. Prior to joining us at NYU, she was on the faculty of the University of California at Berkeley School of Law for many years, where she also served as interim dean for 1 year. So Deborah and Melissa, welcome and thank you for being part of this event today.
Thank you.
It's great to be with you both, even if just on Zoom. So our plan for today is that I'm going to pose some questions to Deborah and Melissa. They will take up in kind of conversation form between now and about 3:30. And then at that point, I'd love to invite questions from our audience. You can at that point enter questions through the Q&A function on Zoom, and we'll spend about 20 minutes taking up your questions before concluding. So here's an opening question. As we know, this lecture honors Jacob Javits. And as Sibel just mentioned, he's a graduate of our law school, went on to serve in a variety of really important leadership roles in elected office, both at New York State and in the United States Congress. It may be worth reflecting for a moment on his work and his legacy. In particular, it does seem noteworthy today that Javits rose to prominence as a member of the Republican Party and is what someone could call, I think reasonably, a liberal Republican, a political orientation that seems, to put it mildly, somewhat less commonplace today. Given our really polarized politics, could someone with Senator Javits's political profile be successful in public life and public service today? What do you think?
Well, I'll take a stab at it. And first, let me just say thank you to the Javits family for making this possible, and for the Provost's office and the law school for recommending Deborah and myself. And Deborah, of course, it is my honor to share this with you. We go back a really long way, and I'm glad that we finally crossed paths here at NYU and our colleagues. Is Senator Javits or someone like Senator Javits likely to happen now at a time of such intense political polarization? I think it's a hard question simply because we have become so deeply entrenched in our ideological positions that the kind of give and take that I think Senator Javits modeled really is elusive. Certainly we've seen it be quite elusive over the course of the last year. And so, maybe not, but you do see these glimmers of hope every now and again, where we do seem to reach across the aisle in the spirit of a Senator Javits to do things that perhaps are a little out of step with the mainstream ideological visions of each party. And that perhaps is heartening. But I think the question of polarization is a really important one, and one that has shaped certainly the political discourse and landscape over the course of the last year, and likely will continue to do so going forward. And we could think about polarization as being something disadvantageous or deleterious to the political landscape, or we might just think about the idea that the way that people regard certain values or commitments as being fixed is perhaps heartening in itself. I mean, there may be a way of thinking about polarization, or at least some sorts of values and commitments, as being so fundamental that we cannot be selective or itinerant about them, and that we cannot compromise on those particular commitments and values. And I think if you think about it from that perspective, that is something that someone like Senator Javits, I think, could be behind, even if it doesn't necessarily comport with his vision of cross the aisle compromise.
Deborah, what do you think?
Sorry. I also just want to thank you for moderating the conversation, for making this award possible for Melissa and for me, and thank you to the Javits family, to the university. Also want to congratulate Cameron and Anna. I've had the privilege of working with both of them as research assistants at the law school. And to also just say that I'm really honored to be here with Melissa. We go way back to when we were both at the Legal Defense Fund, so it's really wonderful. In terms of Senator Javits' story, I think his personal story resonates with me. His family, his father was a janitor and his mother sold items from a push cart. His journey really does, I think, speak to me. We celebrate rightfully the end result in his time in Congress and as Attorney General of New York, but I think we should pause and think about the journey and what it took for him to get there, because it reflects fundamentally, I think, the idea of the American dream, that notion that everyone deserves a fair shot at a better life. And the idea that education and investment in a child could transform that child's life and trajectory. We used to believe, I think, that it was a foundational part of American society, that where you start in life does not dictate where you end up in life. But I don't know how many of us really believe in that anymore. I think we know that to a certain extent, it's never been universally true. It has always mattered where you are from. It has always mattered who your parents are, what color your skin is, how much money you have. And it resonates with me personally, because I'm not who many people think of when they envision an NYU professor. I'm a first generation American. My parents are from Jamaica, as are Melissa's, something else we share in common. And I'm the first person in my family to graduate from college. My father is 75 years old. And up until last year, when he was hospitalized with COVID, he worked as a machinist in a factory every day. And my mother spent her career processing bills in a bank. But yet here I am, despite all of those odds. And so I think Senator Javits' life reminds us what is possible. But more directly to your question, Trevor, I agree with everything Melissa said and could not say it any better. I think his profile as a liberal Republican may seem like an impossibility today, but as Melissa mentioned, believing in equality as a core fundamental American value should not be seen as a Republican or Democratic issue. Freedom should be an issue of universal concern. Equality and equity should be an issue of universal concern. Wanting to end suffering and economic inequality should be a universal concern. And the debate and discussion between parties should be about how we get there and not whether we should be trying to get there. And of course, the choice between equality and freedom that we see so often set up, I think is a false choice. There's fundamentally no competition. Equality is necessary for freedom. So Senator Javits was a Republican at a time when I think Republicans were leaders in the fight for civil and human rights. People like Lowell Weicker Jr. and Jacob Javits were part of that legacy. But like so many other areas of American life, racism eroded that. And as Democrats like LBJ embraced civil rights, the Republican Party shifted to the right, often with an explicit embrace of white supremacy. And that has meant that there is less room for people with Senator Javits' profile. But ultimately, I think America will be best served by a robust multi-party system where the debate is around policy rather than a debate about the fundamental worth and dignity of immigrants or LGBTQ folks or people of color, or the value of diversity.
Great, thanks to both of you. Still sticking with Senator Javits' own career, both when he was in the House and then later in the Senate, we associate him, of course, with a deep commitment to civil rights. We know that he publicly opposed continuing appropriations for the House Un-American Activities Committee in 1948. In 1954, he supported a bill banning segregation in federally funded housing projects. Perhaps most meaningfully and importantly, he endorsed anti-poll tax legislation in the late 1940s on the view that that kind of legislation was aimed precisely at suppressing political participation on the part of minorities and the poor. And that example in particular, that last one, seems especially resonant these days. We know that last week, the State House in Georgia enacted quite sweeping election reforms there that many experts predict will have a significant negative impact on political participation, especially by minorities and the poor in that state. We know that legislatures around the country are considering comparable legislation. Thinking in particular of Senator Javits' own career and example, how should we think about these current efforts that are apparently designed to retool the political process itself? Why don't we start with you, Deborah, and then.
Okay. First, I will say I'm proud that the ACLU has joined with others to challenge that legislation that was passed in Georgia. I think that what we are seeing is heartbreaking and it's disgraceful, but it's also totally predictable. The reaction to increasing political participation by people of color has always been a wave of voter suppression and efforts to exclude people of color from the political process. The 2008 election was the first presidential election in American history in which voters of color were 1/4 of the eligible electorate. And that election also saw a massive shift in the racial composition of early in-person voting, with Black voters casting their votes early in person more frequently than white voters. And the result was an unprecedented effort to cut back early voting in states that included North Carolina and Ohio and Wisconsin and Florida. And then we saw voter ID laws coming up across the country. And it is what we are seeing today. And again, that the fact that it's predictable doesn't make it any less heartbreaking. The barriers and roadblocks to political participation that we've seen are an incredibly dangerous challenge to our democracy because it reflects the desire of some folks to hold on to power completely and indefinitely, and granting access to others only when it serves their purposes. And since the founding of our democracy, Black voters and other voters of color have had to overcome really relentless efforts to block us from casting our ballots. But the intimidation against voters of color is growing stronger and was more rampant and widespread during this past election than it had been in any other recent election. And now everything that we did, all the steps that we took that enabled Black people and other people of color to vote in record numbers are under attack. And I know that there are folks here who are not lawyers, so maybe a little bit of background and history would be helpful in context. So of course, while the 15th Amendment prohibited the denial of the right to vote on account of race or color, but of course, I'm sure Melissa will point out, did not include women. In reality, Black people who wanted to exercise their right to vote were intimidated, beaten, sometimes killed. And those brutal efforts were followed by literacy tests, poll taxes, grandfather clauses. So the fight to keep people of color from voting started with outright denial and brutality, and then it evolved into creative and ingenious methods to deny, dilute, and then suppress the right to vote. And we did have a period of relatively robust participation, but then there was retrenchment. And although there are no literacy tests and grandfather clauses today, we see a new generation of retrenchment and tools that are being employed across the country, including discriminatory redistricting and annexation plans, these voter identification and verification laws, voter purges, at-large election schemes, the lack of voting machines in communities of color that resulted in the 4, 5, 6, and 7 hour long lines that we saw. And so the evolution we are seeing from rampant discrimination, denial, and suppression to progress and participation back to rampant discrimination, denial, and suppression has a lot to do with the Voting Rights Act of 1965 and how it has been stripped of its most powerful provisions. And traditionally, we have framed it as a fight for access to our democracy. But now we see the fight is really to just protect our democracy. At the inauguration, lots of people celebrated the fact that our democracy prevailed and everything was upheld. But I think we were far closer than any of us want to acknowledge or that any of us should be comfortable with. So both protecting access for all eligible voters and what has become clear, the need to protect and shore up our democracy for everyone is critically important. And as we heard a lot over the last several months, democracy is a threat to white supremacy. And so white supremacy is a threat to our democracy. And finally, I'll just note that I think it's important to point out that the record turnout of voters of color in the past and in this election cycle is not evidence of success. The record turnout of voters of color was supported by unprecedented efforts to make it easier for all people to vote because of the pandemic. But even in the midst of this historic effort, we saw carve-outs to diminish the support for voters of color, removing mailboxes in Black communities, slowing down the process of mail, people waiting in line for 4 and 5 and 6 hours. But the fact that we saw those incredible long lines again was a sign of voter suppression. And the record turnout was an example of efforts of private organizations and individual people determined to get people registered to vote, to overcome the rampant voter suppression and voter intimidation. And it's a shame that those efforts have proven to be necessary.
Melissa?
I agree with all of that. I mean, I think you cannot understand what we are seeing in Georgia without reflecting on it as part of a backlash to overwhelming mobilization of voters, not just African-American voters and voters of color, but also younger voters, which have traditionally skewed toward a more progressive path. I think that was an incredibly powerful movement that we saw in November. And I think you can't understand what we're seeing now without thinking about it in that context. And as Deborah said, it's a very familiar playbook. We've seen these oscillating fortunes repeatedly over the course of our history. An expansion of political power is met with an effort to scale back that expression of political power at every turn. It is worth thinking, though, about what paved the way here. And as lawyers and as professors who work in a law school, I think we'd be remiss if we focused exclusively on simply one aspect of this problem, the legislature that are promulgating these laws. These laws would not even be possible if it weren't for the Supreme Court's decision in 2013's Shelby County versus Holder, which eviscerated the preclearance requirements of the Voting Rights Act. And essentially under those preclearance requirements, states that had a history of engaging in suppressive tactics were required to have any change in their electoral policies or laws vetted by the Department of Justice and approved before they could go into effect. With that 5-4 decision of the US Supreme Court in 2013, the preclearance formula was dispatched with and was no longer necessary. And that basically broke down the entire system of DOJ preclearance. And so now the states are virtually unfettered in their ability to change their laws and to have them go into effect. And the only check that we have is under Section 2 of the Voting Rights Act, which allows for litigation to be brought to challenge it. And obviously litigation is a very different prospect. It is more time consuming. It requires individuals to have the resources to file a lawsuit that will require expert testimony in some cases and lots of other resources. I think it's not surprising that in Georgia, the folks who are bringing these lawsuits are the ACLU, the NAACP Legal Defense Fund, large-scale organizations that are mobilized to do this kind of impact litigation as opposed to individual voters. So that's an important part too. It's also worth noting that right now pending at the United States Supreme Court is a challenge to a set of Arizona laws that, although they are in Arizona, will certainly have a wide-ranging impact on voter laws throughout the country. And that's a challenge to Section 2 of the Voting Rights Act and the scope of Section 2 and whether and under what circumstances lawsuits can be brought and how courts will review those lawsuits challenging voter legislation under Section 2. So it may be the case that even as these lawsuits are filed to challenge these laws that have been enacted in Georgia, that the Supreme Court may intervene yet again and change the landscape once again to make it harder even to bring suits under Section 2 of the Voting Rights Act. And so, that's all to say that we are just seeing the tip of the iceberg here. Georgia is among the first states, but there is certainly a more concerted effort among Republican legislatively led red states where I think we'll see more of this in the future. So Georgia is just the beginning of what I think will be an onslaught of more suppressive legislation aimed at limiting voter participation.
I just wanted to add, as Melissa talks about the onslaught around the country, it is distracting advocates from doing the kind of affirmative work that I think we need to do, not just defending the victories that we have won in the past, but really taking steps to move us forward, to making our democracy more open and accessible to everyone, to really moving in a direction where we're treating voting rights like a fundamental right and not like a privilege. But instead of doing that work to build a system that is more inclusive, we're fighting for the limited victories that we've had already.
Can I say, like, about that point too? And I thought, Deborah, the point that you made about how different the sort of Republican position is over time. And I was thinking specifically about reproductive rights, where I think all of the things that you've said would apply as well. And there's a period of time in the 1960s and 70s where Republicans were the most stalwart proponents of family planning measures. Richard Nixon signed Title X into law. Ronald Reagan here in California wrote into law, enacted the first Therapeutic Abortion Act. George H.W. Bush, the father of George W. Bush, was known as Rubbers Bush when he served in the House of Representatives as a representative from Texas, because he was so supportive of family planning. So this is an issue that has become so polarized and associated with Democrats over time, but it wasn't always that. And indeed, reproductive rights, like racial politics, were used as a wedge issue to really divide voters and to create a different kind of electoral coalition and landscape for passing these other laws that deal with other aspects of our democracy. So, I mean, all of this is interconnected. So we are talking about voting rights, but voting rights and what happens on the ground in terms of electoral policy have huge repercussions for reproductive rights, for racial justice, for social justice, access to medical care. There's no way in which this picture is not intertwined and inextricably linked.
All great points. And does strike me that the same point you made, Melissa, about decisions of the Supreme Court having created the conditions of possibility for new democracy restrictive legislation like the Georgia bill, the same point can be made about the reproductive rights space as well, of course, that state legislation restricting right to abortion, of course, is possible to the extent that the Supreme Court allows it to be possible. And these things, the one supports the other. It's hard to avoid on the voting rights front. It's hard to avoid, for me anyway, thinking about Justice Ginsburg's dissenting opinion in that Shelby County decision. The premise of the majority's decision in Shelby County, I take it, is something like we've made so much progress with respect to racial justice and access to the vote in particular, that the pre-clearance protection is no longer required, no longer necessary. I guess the further premise is we should not expect to see legislation like the Georgia legislation because of the progress we've made. Of course, Justice Ginsburg in her dissent says throwing out that Section 5 pre-clearance mechanism when it has worked and is continuing to work to stop discriminatory changes in voting law is like throwing away your umbrella in a rainstorm because you're not getting wet. I guess that would, to extend the analogy, that would make the Georgia bill one big thundercloud. And perhaps it can inspire some reconsideration, although I don't know that I'm optimistic about that. The title of this conversation today is Democracy, Inequality, and Civil Unrest. So if we, and these are overlapping, of course, but if we pivot from looking at democracy head on to thinking about inequality and structural inequity, this last year, of course, has provided many moments for all of us to think anew about those incredibly important issues, and has provided a new lens through which to see these issues and a new way of thinking about them. And I wanted to ask each of you, you work in these spaces, you teach and write in these spaces, how has the last year affected you? How has it, if at all, changed how you teach, how you think about inequality and inequity? Melissa, let me start with you.
It's a terrific question. Yeah, I will say this. One of the things that has been, I think, laid bare by the pandemic is not only how critical inequity can be in outcomes, but how inequity actually gets compounded over time. And I don't know that we necessarily thought about that as robustly as we could have before the pandemic. And one example that I'll just draw from is the question of public education. Once schools went to online learning, it became obvious that the digital divide that many families of color experience and lacking access to Wi-Fi or even having computers to be able to use was going to create not only short-term problems for being able to attend school, but would have longer-term deleterious effects on learning. And that became very clear, but that had always been clear. That had always been the circumstance. And I think we were able to see in that moment that the question of advantage or the absence of advantage could be compounded such that what we have generally thought of as merit or achievement is really just about the compounding of advantage. It may be because of natural talent or whatnot, but at bottom, it is also about opportunity and the compounding of opportunities over time that allow individuals to succeed. And when Deborah spoke about her family, I thought a lot about my own. Like my family circumstance is very similar to Deborah's. As she said, I too am the daughter of Jamaican immigrants. I'm the first person in my family to attend law school. What would have happened if we'd had a global public health crisis when I was going to school? Like my mom worked full time. There was no one around during the day. I mean, like when I think about my childhood now, it's sort of, my children think I was an orphan when I tell them that, I took myself to school every day and I made my own lunch. And I have to remind them they've actually met my parents. So no, I was not actually an orphan. But that's not the circumstances I think that we think about. We imagine that children will have a parent, either or someone who will be available to them to help with that. And it's just not the case for everyone. It is normatively what we think about, but it may not necessarily be the case for everyone. And if something like this had happened during my childhood, I wonder what my outcomes would have looked like. I wonder what that year at home by myself, trying to get online, trying to do school without a lot of adult supervision would have looked like. And I think I've been incredibly successful, but I also think I landed a lot of lucky breaks.
Deborah?
Yeah, it's such a hard question because the answer of how has it changed or my thinking, my teaching, my actions, it's just so many ways. But focusing on the two big things that happened in 2020 and following up on what Melissa said, the devastating impact of COVID on marginalized communities, and then the racialized police violence, but also the broader impact of the criminal legal system. I think that the last year has reinforced that not only do we need to think about the problem of inequality as systemic, but attack and fight it as a systemic problem. I found that many people really don't understand what it means to address systemic issues. So we will say it's a systemic problem, but what most people are thinking about when they think about racism is still a person or a group who dislikes someone of a different race and acts on that. Or they're still talking about implicit bias, which allows us to focus on unconscious feelings and not take responsibility for the actions that also accompany that implicit bias. But thinking of racism only in those terms really misunderstands the true nature, power, and persistence of racism. This understanding of racism overlooks the compounding that Melissa talked about. It overlooks the centuries-long impact of inequality, of race-based laws, policies, and practices that have caused and perpetuate the racial inequality that we're seeing today. It really misses the racism of sending your children to an under-resourced, heavily segregated public school, which constantly underprepares its students for college and life, and then puts them on a path to involvement with the criminal legal system. Those definitions and smaller actions miss the racism of living an hour and a half away from decent jobs because your community is ill-served by public transportation. The lack of access to supermarkets providing affordable and healthy food while your children are sick because they're exposed to environmental stressors like a highway that runs through the middle of your community. It's really difficult, if not impossible, to find a single actor responsible for those harms, and even less likely that there's going to be evidence that any current actor was motivated predominantly by racial animus, but it is racism nonetheless. And the focus on explicit acts of racism presumes that by eliminating those aberrant behavior of just a few bad apples, we're going to root out bias within our system. But again, that limited understanding means that we are using tools that are too small and really too narrow to be effective. And it means that we're not acting in a way that challenges the many ways that racism fundamentally persists in its power. And if we look at systemic racism and consider what I and other people believe are the pillars of systemic racism, laws and policies, our physical and community structures, our social systems and institutions, and then narratives and the stories and counter stories we tell. I think COVID is a powerful example of systemic racism because it pulled from every one of those pillars. COVID-19 was introduced into a society and systems that are racially discriminatory in every way that we experience racism: individual, institutional, structural. People of color are more susceptible to the impact of the coronavirus because of years of inequality. We're more likely to be exposed to the virus. We were at greater risk of developing complications. We had less access to the vaccine, less access to healthcare, and we're also going to experience a disproportionate share of the social, emotional, and economic fallout. And in the clinic I teach, I try to make sure my students leave with an accurate understanding of how systems, local, national, international, political, economic, social, physical, and cultural, shape inequality. And that to affect change, not just their individual clients have to be focused on, but for the community and clients to come, they also have to attend to the role that these larger structures and systems play in creating and maintaining subordination of a community. And I try to make sure that our work in the clinic and the work that they're doing, and that they understand the work that they do after they leave the law school, has to try to attack every pillar of systemic inequality. And finally, I've been thinking a lot recently about long-standing calls from legal scholars and racial justice advocates for a third Reconstruction, and trying to figure out what that would mean, and how we can engage in a third Reconstruction that would meaningfully advance racial justice and address the historic and systemic racism and inequality, and the compounding that Melissa talked about, how we can center human dignity and community equity as central to our racial justice agenda. And as we look forward to how we challenge racial discrimination, we also have to think about how we construct a positive conception of racial equality. It's not all about tearing down, it's also about how we build up. In linking it back to Senator Javits, I know that he made efforts to challenge and ban segregation. And unfortunately, I think it's a fight we're still fighting, but seems to be less of a priority for many people who are fighting equality. And I think we need to double down on fighting segregation, and at the same time, expanding access to opportunity within communities of color. Segregation is at the heart of many of the disparities we saw in COVID, and an important contributor to the racial disparities in our criminal legal system. And the systems this country has really effectively built to protect and maintain segregated communities and spaces have a tremendous negative impact on those who are left out, because we cannot separate the places that people have access to from the opportunities that people have access to. And so I've thought more about how to go about challenging segregation as well, because of the fundamental structural role that it plays in locking in, solidifying, cementing, continuing the kind of inequality that we see.
All of that, though, I think assumes that the state's role is about actively cultivating systems of inequality. And I think, everything that Deborah says suggests that that is certainly a pernicious aspect of this. But I think we could also think about ways in which the state contributes to systemic inequality in ways that are not necessarily active, but really are just about benign neglect. And one of the things that I've observed over the course of all of this is just how much the state and all of us assume that the family will be the vehicle by which we accommodate the dependency of the United States, whether it's the care of children or vulnerable adults. We rely on the family in a lot of ways to do that. And there's very little state support for that kind of work. The child tax credit is vastly under-resourced relative to the cost of childcare in the United States. We have very little other forms of subsidy to the family. I think what we found during the pandemic is that school is perhaps the largest subsidy that the government provides to families. And we don't necessarily think of school as a kind of childcare subsidy, but for many working parents, it is the essential scaffolding of our working lives. And we certainly found that to be the case when public school receded as an available option for instructing children, where parents were forced to take up that slack. And so I think part of our challenge to build back better is not simply to take into account the ways in which the state actively facilitates inequality, but ways in which our assumptions about who does what and what kind of work needs to be done, and whether the state has a role in any of that, whether those assumptions also contribute to inequality, and specifically a kind of gender-based inequality that has been very deeply embedded and persists despite our changes in other aspects of life.
Yeah, I want to stress what you said, the benign neglect. It's incredibly important. And it reminds me of the tendency that we have to ignore the challenges of trying to support Black communities and other communities of color so that people can thrive within their own communities and access opportunity within their own communities. So I think the law, we as lawyers, disproportionately focus on how to get Black people and other people of color access to traditionally white spaces and the opportunities in those spaces, home and school, but less time guiding and shaping and thinking about how we support Black schools and Latinx schools and the Black communities and Latinx communities, how we support the long-term residents of those communities in the face of pressures like gentrification, and how we support and build those communities to the benefit of their residents so that everyone, whether they're living in a predominantly Black community or predominantly Latinx community or white community, has access to the tools, resources, and support that they need to live choice-filled lives. And instead we tend to ignore those communities, and they suffer from that benign neglect.
Really important points here. I particularly appreciate what you've both said about looking for sites of systemic racism, institutional inequality, in the obvious places where you might be able to identify a sort of ill-motivated bad actor, but also in the less obvious places where the mechanism may be, as you've just said, each of you, benign neglect. And I think of your own scholarship, Deborah, focusing on infrastructure as a place where, at a minimum, if we're not careful and thoughtful about it, we're liable to, through large infrastructure projects designed to bring public benefits to communities, to perpetuate systems and structures of institutional racism. And I suspect that a lot of the folks in the audience today don't think of infrastructure as a site of big transportation projects, as projects of racial justice or potentially racial injustice if we're not attending to that. And in this moment of perhaps infrastructure being on the horizon, that seems worth bearing in mind.
Yeah, infrastructure, transportation policy,
right.
Transportation infrastructure in particular. I think about it in the context of historian Manning Marable, who kind of viewed racial inequality through a different framework than we normally do. And it is not about exclusion. He thought it was a result of perfect inclusion, and that our systems and structures were deliberately and specifically designed to maximize Black oppression. And according to him, our systems have been developed in a way that is purposefully designed to underdevelop Black people and Black communities. And I think about that when I think about our transportation system and infrastructure system, and the way that infrastructure has permanently embedded, or at least we thought permanently embedded, into the kind of our economy, culture, society, this structure of inequality. And now we have an opportunity to do something about it.
Or embed inequality even further. I mean, one of the complaints that was made during the Obama administration with TARP funds and the infrastructure projects that were intended to resuscitate the economy was that they were basically funneling an income transfer to industries that were largely populated by men: construction, transportation, the auto industry. One way that you might think about public policy in this particular moment is using the carrots that the federal government can provide through infrastructure subsidy to encourage the diversification of some of these industries that will be on the forefront of any kind of infrastructure expansion. So providing expanded funds for those firms that are able to show that they have women who are heading for or foremen or heading teams or whatnot. There are lots of ways in which the government can help to cultivate a more diverse workforce, even as it thinks about these infrastructure projects that are aimed at making the sort of fabric and landscape of our daily lives more amenable to just daily use.
Yeah, I think we have to think deeply about how we engage in infrastructure projects for the reason that you mentioned, but also for the other ways that it could be used as an opportunity and tool to further cement inequality and segregation, as opposed to as a tool of uplifting equality. Because again, when we think about highways, and during the 50s and 60s, when our highway system was originally built, we destroyed Black communities, tearing down houses and schools and churches and buildings and displacing thousands and thousands and thousands of people in a way that really locked in segregation and economic inequality. And as we go about engaging in rebuilding these highways, which so often are really literally crumbling or don't meet federal guidelines, those same communities that have struggled for decades are still in the way, in the path of those bulldozers. And so we have to think deeply about how we use this as opportunity to reinvest, to build up, support, to make amends for the decades of harm, rather than using it as an opportunity to re-injure those and reharm those same communities, finding ways to make sure that poor communities of color don't continue to bear a disproportionate amount of the harms of our transportation infrastructure, and not get an equal amount of benefits. And again, how we employ and engage poor people of color in those projects.
So thank you. Let's layer in another element of the last year. I'm thinking of police violence in particular, targeting communities of color, which of course is not some new innovation of the last year. It's been a recurring theme over the last decade. If we think, of course, of Ferguson, which feels on the one hand like a long, long time ago, but on the other hand was not. And of course, this history goes back much more than just the last decade as well. All of that said, it does seem fair to say that broad attention to and concern for police violence, especially targeting communities of color, has increased over the last year, that the killing of George Floyd in particular, thinking about that event, given the opening of the trial against the trial of Officer Chauvin this week, does seem to have been a galvanizing moment. And I want to ask each of you how you think about the last year in that context, and how the events of last summer in particular have, if they have, in your view, changed the country? How have they shaped your own thinking about the quest for racial justice and civil rights in this country? I can't remember who we started first with last, but Deborah, let's start with you. Then we'll
okay. As the mother of two teenage boys, this is just a tough issue for me. I am scared every time they leave the house. It was really, raising two teenage boys in this time is not for the faint of heart. And as you said, I think the issue of police violence has always been a problem. We're talking about it more now, but it's always been a problem in communities of color. From their inception, police have been tasked with protecting power and privilege by exerting control over Black people and enforcing racial order. We know that modern policing has its roots in the suppression of slave revolts and in the creation of patrols to capture enslaved people who had escaped. And during Jim Crow, police forces throughout the South brutally enforced segregation and joined in with lynch mobs. And during the Civil Rights Movement, police officers beat protesters who marched for equality. And police were enlisted to ward off residential integration and protect the people who were terrorizing Black families who had dared to move into historically white neighborhoods. And so it is a deep and really painful history that we're dealing with. I think we're still in the beginning of a very long overdue conversation about the racialized harm in policing and the need to reimagine policing and public safety. And I think that that conversation is not advancing at the pace or in the way that it needs to, given the harms that every day people are still being hurt within our system. For every day people are dying, and we need to move faster. Today we're still using the police as tools to subjugate, control, to regulate, to devalue Black people and other people of color. Today, Black people are still disproportionately killed by the police, stopped by the police, arrested by the police, experience physical and emotional harm from their interactions with the police. And yes, we've seen some changes, but I think not the kind of fundamental structural change we know that these repeated incidents call for. And again, lives are being lost and destroyed every day. And kind of reflect on where we are over the past year. We can start with how officers do their jobs and engage with the community. And if we just look at the past few months, we can compare the way an elected official, a Black member of the Georgia legislature, was dragged out of the state capitol by police for doing the job she was elected to do, or how New York police restrained, handcuffed, and pepper sprayed a distraught 9-year-old Black girl, compared to how a white man who had just shot and killed 8 people, mostly Asian women, was armed and dangerous and was peacefully taken into custody, and how he was treated with kindness and empathy after his arrest. So we know that it's possible. We just know that it's the kind of policing that you may want to see is not being done with a regularity in communities of color. And then following the murder of George Floyd and Breonna Taylor and Rashawn Brooks and far too many others, we saw these historic protests right here in Washington Square Park and throughout New York City and around the country, demanding justice and an end to the systemic violence that police inflict on Black and brown communities and on Black and brown people. And it seems that we didn't learn that lesson because the answer to so much of the protest was the brutality that we were protesting, that people were protesting. And the answer to protest over police brutality is not more police brutality. And then again, last summer, when we saw police officers responding to protesters in this way that not only inflicted more physical injury, but then also further eroded the trust and relationship that we have with police. And in terms of accountability, if we focus on the worst conduct, we have a murder trial that just began, which is tremendous progress. But we saw that there was no charges and insufficient consequences still in the killing of Breonna Taylor while she slept in her bed, or Daniel Prude, who was killed by officers while he was experiencing a mental health crisis, or for the shooting of Jacob Blake. We have seen some progress with the House of Representatives passing the George Floyd Justice and Policing Act. So it's not that there's been no progress. It addresses a wide range of policies and issues regarding policing practices and also law enforcement accountability, including measures to increase accountability for law enforcement misconduct, to enhance transparency and data collection, to eliminate some discriminatory policing practices. But however, in each of these areas, the bill really just does not go far enough. And it does not do enough to root out the kind of systemic racism that Melissa and I were talking about and transform the way we approach public safety in communities of color. The underlying problem with policing isn't just the lack of oversight policies, or the lack of training or the lack of procedures. And while doing more to radically change each of these areas is essential for immediate harm reduction, the problem is more insidious. We need to see concrete, immediate steps to hold officers accountable. But beyond accountability for individual bad actors, we need to see systemic accountability. We need to confront the systems of racism. And that's going to take more than holding individual purveyors of harm and violence accountable. We need to do more to shrink the footprint of policing in our communities and invest more in the resources and institutions that are going to allow communities to thrive. Affluent white communities already live in a world where they choose to fund youth, health, housing, and education as their primary investments in community health and safety. And we need to identify and unravel the bias that leads us to believe that the same is just not possible for communities of color.
Melissa?
So I've been covering the Chauvin trial for MSNBC for the last couple of days, last week, I guess. And one of the things that struck me in covering the trial was the responses to the juror questionnaire that was circulated to potential jurors, and how many people indicated on that questionnaire that they recognize that there was a disparate impact of police violence in certain communities, or that policing was different in certain communities. And that to me seemed really meaningful and relevant, and a kind of change that I think has only occurred over the last couple of years. I remember the Rodney King trial back in the 90s, and I just don't recall individuals having the same level of skepticism of policing, or even the police writ large. There seemed to have been, back in that period, just sort of an understanding that the police were there for public safety, and it was really their interactions with bad actors that led to violence. And here it seemed there was a more nuanced, I think, understanding of what policing looks like in communities that may not necessarily look like your own. And a number of prospective jurors made that clear when they were questioned during the jury selection process. A number of them were still seated, even though they said that they recognized that there was this spate of police violence against communities of color. And that to me, I thought, was a really important shift to make the question of disproportionate impact in policing relevant, accessible to lay people, to understood by people throughout the country. That seemed to me a quite extraordinary shift. And I think part of it is due to what we saw last summer, the protests. I think it's not unrelated to the fact that on January 6th, we saw another protest movement that was met with a very different response from police, or a much more a less accelerated response from the police in certain respects. And that certainly may have played a role in this, in the way jurors understood it. But it does seem to be fundamentally different. Importantly, though, I think the change in racial attitudes can also be harnessed and used for ends that I think are less progressive. So when I think about the reproductive rights landscape, one of the things that I'm seeing right now is the proliferation of laws that prohibit abortion if undertaken for purposes of quote unquote race selection or sex selection, or if there's the detection of a fetal disability. And those laws are justified in the language of racial equality and sex equality and disability equality. And that to me is a really interesting shift too, sort of recognizing how powerful the language of equality is and racial justice is. Those who are opposed to abortion have harnessed it. And we've seen this play out in the court. In 2019, Justice Thomas wrote a concurrence in an Indiana abortion challenge where he linked abortion to a history of eugenics and the idea that abortion was part of a larger white supremacist plot to basically deracinate the Black community through family planning measures. And we have seen that sort of percolate at the lower federal courts over the last 2 years. I think it is very much in the ether. And it is a campaign against reproductive rights that is explicitly understood as an intervention for racial justice. So when people say Black Lives Matter, you have those in the anti-abortion community saying Black unborn lives matter. And so there are ways in which the success of these movements are noticed, are reflected upon, and are ultimately harnessed for different purposes as well.
That's a really interesting point, and folks in the audience should know that Melissa's produced some really important scholarship about this very set of arguments that she's just identified, a kind of harnessing of the success of some progressive movements to kind of invoke those same principles, but then turn them back for evidently quite different ends. There's some kind of parallel going on here. I think if we also, you brought up the activities at the Capitol, Melissa, on January 6th, and we could compare that event that some who might defend it would describe as a set of acts of civil unrest to protest activity of last summer. And if we lay those two beside one another, how do you think about what those two episodes in particular, sets of episodes and the experience of the last year, what it tells us about the state of civil unrest, of protest and dissent in this country today?
I think you can draw a straight line between what we saw on January 6th to what we are seeing now in Georgia in terms of those restrictive laws. You know, there is a group of individuals in the United States who believe that they had an election stolen from them, that the mobilization of minority voters, of youth voters, enabled the other side to steal an election. And the insurrection at the Capitol was just, I think, phase one of what they understand as civil unrest or a protest movement. But what, you know, those of us who have seen political unrest in other countries, as I have, would say that really looks like an attempt to unseat or to dismantle a democratic government. And you know, they don't see it that way. And maybe this goes back to the entire question of polarization that you posed at the beginning. We have very different views of what happened on January 6th. There is a group of people in the United States who understand that as a legitimate expression of dissent against what they viewed as a steal, as a political power grab. And there are those of us who say that was an attempt to completely disrupt the democratic processes of government. And it was the kind of thing that we ordinarily don't see in the United States, and indeed is sort of completely antithetical to the idea of democratic government. But we're really fixed in those positions, and there's not a lot of wiggle room in between. What I think is most concerning about it is not simply the violence that we saw on January 6th. And you know, to be clear, it was not just simply violence writ large, but a racialized kind of violence, the way that they were talking about people of color. There was a sort of gender-based violence. They were walking through the Capitol, calling the Speaker of the House, Nancy Pelosi, all kinds of epithets. There's a kind of anxiety, I think, about what leadership now looks like in this country, because it is a more inclusive model of leadership. And all of that, I think, is about demographic change. And then that, I think, there's a straight line between those kinds of anxieties and what we're seeing in Georgia and indeed in other states that are promulgating similar laws, a kind of change in the electorate, a change in the nature of the country, and the idea that the America that you have known may not be the America that you have in 20 years. It will look different, and there won't be room for you, or you won't have, or you won't occupy the same space that you previously occupied.
There does seem to be a lot of trouble in the connection between the second to last sentence you just said and the last one. That is I think, to me at least, a dimension of the problem does seem to be that to say that the United States 20 years from now demographically will look quite different than it did 20 years ago is not necessarily to say that there isn't a place in the United States for anyone after that change. But somehow the first statement, in at least some the minds of some, seems to lead necessarily to the second. And in that is a lot of our problem, I think. Please. Yeah.
If there's an investment in a particular kind of hierarchy and change in the nation means that that hierarchy no longer has the same salience, right, that's a fundamental shift.
Absolutely, yeah.
I would agree that we are seeing a resistance to a nation that is more diverse than it has ever been, and it is growing more diverse. And January 6th reflected that. and the attempts to disenfranchise Black voters and to brand our participation in this democracy as illegitimate, but it started long before that day. It also included efforts to end immigration by people of color, to include the citizenship question on the census. It includes the challenges to the use of race-conscious admissions programs at storied historically white institutions like Yale and Harvard, and our attempts at diversity and inclusion here at NYU. It is in line with backlash that has plagued American politics from its beginning. But you asked also about protests, and I just want to stress a little bit about how powerful the protests were over some of the ones demanding racial justice. And peaceful protests by people of color have always been a really potent force to drive overdue reform and transformation of discriminatory policies and institutions. And it's a powerful reminder of the political power and strength that we hold in our communities to drive change, to change the conversation. And peaceful protests by people of color have often really led to overdue reform and transformation. We saw that with protests following the murder of Trayvon Martin in 2012 and the police killing of Michael Brown in 2014. And we saw that this summer. And so it's not surprising that we've also seen a reaction to that, as we often do with shows of power and progress. And we're seeing that there are efforts by the federal, state, and local governments to kind of stifle those voices of protest of Black people and others who demand racial justice, either directly or by providing cover and support to those who would. So we saw, and I mentioned the aggressive police responses to the protests, but we are also seeing overly aggressive federal prosecution of protesters. We've seen several jurisdictions across the country have adopted laws that criminalize protest behavior, and we're seeing the conflation of nonviolent social justice movements with domestic terrorism. And all of those are, I think, are a threat to and in response to the power of protest. So we need to celebrate the power of protest, but also to be mindful of those kinds of threats that are creeping up against it.
Thank you. I want to invite folks in the audience to pose questions, and we'll turn to them. You can use the Q&A function at the bottom of your Zoom screen. But while people are doing that, let me just pose one last one that I hope flows from what you've each just been speaking to. So thinking in particular about the role of law schools as training grounds for lawyers and advocates, and thinking also about the protest activity of last summer and the extent to which some change already has been achieved. And there's certainly a need for more, and one hopes a promise for more. But a lot of the change that was driven by protest activity of last summer was, I think, can be characterized fairly as grassroots organizing, as operating outside of the recognizable structures of law, even of governance. And I wonder if that raises a question about what the role going forward can be, should be, for lawyers and advocates operating within the familiar structures of law and public power. Is there a role in seeking the change that we would like to see around issues of police violence, racial justice, even basic democracy promotion, for lawyers and advocates from within a system, if what needs changing are the institutions of that system? Or is this going to have to be led by more kind of popular grassroots effort that is where lawyers don't play a central role? What do you think, Deborah?
I was actually going to let Melissa go because I thought.
Okay.
It's such an interesting question, Trevor, because I think right now law schools are in this really interesting moment. We're obviously more remote from our students than perhaps we ever have been. And yet we are trying to cultivate a sense of connection with them. And then there's all of this stuff going on around them. And I think one of the questions is there a role for the law school? I mean, at bottom, is there a role for a law school at a time where it seems like so much of the problem may be in the institutions that law has created and cultivated over time? And you know, I think I come down in favor, not surprisingly, like there is a role for the law school. We train people to think critically, and not just about institutions we like, but even the institutions that we like and that we have cultivated. Like that's why our students are here. We see in the classroom that they are being critical thinkers. Right now, the question of criminal justice reform and abolition are clearly on the table. How do you teach criminal law in those circumstances? I don't know that it is simply enough to say, you are exactly right. We just need to raise it all and start from the beginning. I think we have to continue doing the work that we have always done, point out what the problems are, ask challenging questions about what could be, and then allow our students to get to the places where they want to go with that. But it's not necessarily in just sort of abdicating our role in sort of providing them with pathways to think through some of these really difficult problems. It's also the case that, you know, protest and reform is necessarily, I think, extra legal these days because we understand the limits of law and our students understand the limits of law. So we could understand the Me Too movement, for example, as a movement that is explicitly structured on the failures of sexual harassment law and workplace discrimination law, and that is operating outside of law. It may need to have the importation of some legal structures, whether it's due process or whatnot, to avoid having sexual discrimination also bleed into racial discrimination in the way that these policies are enforced. But it is fundamentally an extra legal movement that is happening often on social media and in places that are completely unregulated by law. And I think our students need to know how to think through the vagaries of those circumstances. We could think about what's happening in Georgia right now. I mean, we have the spate of voter registration laws that are being enacted. And the response to that is not simply lawsuits, but also an economic boycott of Coke and Delta. And that is, I think, an incredibly powerful antecedent kind of movement that's happening in tandem. But it couldn't work by itself. Like you needed the lawsuits and you also needed this extra legal kind of protest movement happening in the economic realm. And interestingly, it too is being met with calls of cancel culture. So I mean, the same kinds of moves you see in the legal world, you see in these extra legal movements as well. And so our students are equipped to not only think about those questions in the legal context, but outside of it. And I think for that reason, there is an important role for law schools to play.
Mm-hmm.
It's true. My question was a bit of a setup because I didn't suppose that either of my colleagues were going to say there's no role for the law school to play. But
and I'm not going to disappoint as I jump in. I don't think that a focus on building power from the ground up and centering the voices of those most directly impacted means that there's no role for lawyers and other advocates. We have a role to play in using our privilege and our access to help build that power in communities. We can all learn a lot from our colleague Tony Thompson's book, Dangerous Leaders, How and Why Lawyers Must Be Taught to Lead. We need to help our students gain the skills of collaborative leadership, how to step back sometimes and have our work support other people's work, and for the law to be just one piece of a strategy rather than the centerpiece of the strategy. And I think the protests and the organizing over the summer, both in response to police violence, but also in response to the disproportionate impact of COVID on communities of color and for incarcerated people, were successful in transforming the conversation and leading to tangible change, in part because people were ready for this moment because of the work of activists over decades and organizers and lawyers over so many years. We were seeing the work of so many people who worked on racial justice and challenging inequality long before this moment coming together. Artists had films, scholars had books and articles, advocates had policies and platforms, resources, educational materials, legislation was in the pipeline, and litigation was in the pipeline. So I think it reminds me of John Powell's statement that we can all be part of the circle of human concern. There certainly is a role for lawyers. And if we think about the way to take advantage of this window of opportunity for deep systemic change, I think it requires that we certainly have to identify the tools of inequality, the structure of inequality. We have to use whatever resources we have to tear down that structure. And then we have to figure out a way to build a structure that leads us to equality. And at each of those three stages, I think lawyers have a role to play.
Great. So we've got some terrific questions from our audience. And in the limited time left, let's at least put one on the table. Here's one that takes us back to Senator Javits himself. We seem as a nation to be talking a lot more at one another rather than to one another, which means that when one side wins, the other necessarily loses. We seem to have lost the political ability to address the concept of enlightened compromise, which was a concept really that the questioner associates with Senator Javits. The idea that there can be conversations that lead to compromise solutions, but where the solution is actually better than either of the initial proposals. If that's true, I guess the question is, do you all agree that that's an apt description of this current moment? And if it is, what's the solution?
Again, I think we are pretty firmly entrenched in our positions. I don't know that we have to be, though. I think there is room, and I think we teach our students this every day at the law school. Like, to be a really good lawyer, you not only have to know and believe in your position, you have to know and understand why your opponent believes in hers. And I think we practice that. But I think more generally, what makes the whole idea of talking at each other as opposed to with each other more elusive these days is that we've, I think, lost the kind of generosity of spirit and sort of thinking broadly about where people are coming from. I'm just reminded every day, like, this, because we have such a diverse group of students at NYU, that you really don't know where anyone is coming from, what their past was like, what their views are, and that their views are not necessarily fixed and may change over time. And I've been delighted teaching constitutional law at NYU that, I have students who have come to me and like, I thought you were going to be like a pinko commie from Berkeley. And I was really surprised when you let us play out a whole range of different scenarios and you never suggested that you viewed them as illegitimate or whatnot. And I think that's what we're supposed to do as professors. This classroom is supposed to be a safe space. You cannot denigrate anyone in the classroom, but it is a place where you can exchange ideas, even ideas that you may not necessarily agree with. And part of the work is sort of explaining in a respectful way what the disagreement is, and seeing if the other person can understand that. And I think it's easier to understand where people are coming from if you meet them from a place of generosity.
Yeah, I agree with what Melissa has said, and I think I try to engage our students to help them understand the importance of conversation, of understanding perspective. And I think compromise is important, but I'm also challenged by the idea of compromise with some of the issues that we're facing today, because so many of the disagreements are grounded in issues in which I just think there is no compromise, that we cannot have a conversation if you don't believe in my fundamental humanity, if you don't believe in my right to live, exist, and thrive in the same way that you do. And so, yes, some of this has to be about compromise, and some of this has to be about conversation. But I think it's exhausting sometimes to have to repeatedly try to convince people that you're as deserving as they are, to try to convince people to believe in fundamental issues of equality and access, and to convince people to believe that everyone has a right to exist in our country. And so there are certainly a lot of more places where we can have dialogue, but we need to keep an open mind. We need to hear each other out and be open to what we can learn from people who we think we have nothing in common with. But there are some other places at which I just think the compromise is not the goal.
Well, there are a set of ground rules. I mean, and I think that question of generosity of spirit goes both ways. Like, part of is recognizing the fundamental humanity of the person with whom you're talking. And, and I think our students do that. I wish we could export our students throughout the world, and we should take 1,000 of them a year, Trevor, and then we could do this in a really fulsome way.
Yeah, I also wanted to mention, I think that we also have to apply this rule that I apply in my household when I'm dealing with my husband, who can be challenging in many ways. And it is that we assume the best of the person that we're engaging with. We assume the best in what they said, the best intentions. And I don't think that we extend that kind of grace to each other often enough.
Yes, certainly within a learning community, that seems the key, to begin with a presumption of good faith of your interlocutor. But I think something you said at the beginning of our conversation, Deborah, bears repeating too, which is it's one kind of conversation if there is a shared set of fundamental values, and the debate, even the disagreement, even perhaps very sharp disagreement, is over the best means to the ends. It's another kind of politics, it's another kind of conversation if there aren't any core shared underlying values. And so perhaps part of the challenge going forward is to try and re-articulate what this polity, this community must surely accept as a common set of core values, and to try and reorient more of the conversation into there being a basic requirement to be part of this polity, that there be some shared embrace of those values. I think what each of you said today is really been instructive, certainly for me, and I hope for our audience. I want to thank everyone for joining us. We went on so long with our own questions that we didn't have all of the time that I hoped we might to get to more questions from the audience. But again, thank you, Deborah, and thank you, Melissa, for real insight on an incredibly important and timely and difficult set of issues. And thank you for being part of this today. Let me turn things over to Carla Javits, who's going to offer a few remarks and to close out our event this afternoon. Carla.
Thank you so much. What an illuminating, energizing discussion by two extraordinary scholars and legal minds, Professor Deborah Archer and Professor Melissa Murray. Thank you for enlightening us. I think my father would have relished this discussion. Thank you for bringing my father's voice and legacy into this remarkable conversation. Professor Murray, you mentioned a glimmer of hope maybe for bipartisanship at a time of intense polarization, but in the context of, as you shared, Professor Archer, the reflection that there's core American value we're going to have to uphold. Equality is necessary for freedom, beautifully put. And the fight against segregation, let alone racism, racial discrimination, obviously continues today. The Marion B. and Jacob K. Javits Foundation was started by my parents more than 30 years ago to carry on a legacy of commitment to public service. In addition to creating a congressional prize to recognize bipartisan leadership, some ask us if we can find it. The foundation sponsors initiatives to support students and leaders like Professors Archer and Murray, who exemplify the commitment to justice and fairness that we seek to uplift. In the spirit of today's session, I thought I'd share this conclusion to Discrimination USA, a book my father wrote in 1962 on civil rights, which maybe sadly is still so relevant today. He wrote, "To save ourselves and do it just in time, there must be those who will not permit themselves to be still and compliant, or permit their fellow Americans to be complacent in the face of the incendiary injustices of discrimination and segregation which persist in our society." I hope everyone who participated today leaves with renewed energy to speak out and to do the hard work to make lasting change to impact the systemic inequality we heard about today, and never to be still and compliant or permit our fellow Americans to be complacent in the face of the incendiary injustices of discrimination and segregation, which have persisted in our society for far too long, and we must not and we cannot tolerate. I want to express my thanks and my deep appreciation to Professors Archer and Murray for their brilliant scholarship and inspiration. On behalf of the board members of the Javits Foundation, my sister Joy, brother Josh, our children who are all listening, our treasured colleagues, Jeffrey Kyle, Patsy Perlman, Mark Kaufman. And I also want to thank and appreciate Dean Trevor Morrison, who was such an insightful moderator and contributor today. Beautiful job. And a very special thanks to Deputy Provost Sibel Raver, who over the years has become a valued friend and colleague. She's enthusiastically embraced the association between NYU, where my father attended law school, and the Javits family. We share a mutual commitment to economic and racial equity and continue to explore new ways to collaborate. Today's discussion highlighted the flourishing racial equity and civic engagement we're seeing all over the country. To progress requires policy change, which in our democracy requires legislating for the fully inclusive common good. And I just wrap up with this very short summary of my father's principles for legislating, which my brother has elucidated. For over 30 years, my father had the privilege of representing the great state of New York, 24 years in the Senate. He was a man who spoke his own mind with force and conviction, but he also listened carefully and respectfully to others' point of view. He saw legislating as problem solving, and he had little tolerance for those who just wanted to stifle and thwart the other party. He said what he thought while not demonizing his opponents. Professor Archer just mentioned, let's try to assume good intentions as we do in our families, and not to oversimplify what are very complex matters. He sought to understand what and why others believed as they did, and to keep an open mind. And he sought common ground to move forward constructively, incorporating others' good ideas and concerns, and doing the hard work of finding workable solutions that everyone has a stake in. I want to thank everybody who participated today. Thanks to both of you for the hard work you're doing. I really appreciate a beautiful session today. This concludes our session, and I want to thank the audience for being here today. Thank you so much.